Oopsie, didn't want that. Here we are. Right, so this is going to pain me a little bit. Let's talk about Pathfinder, shall we? Seeing as the talk of the topic of the moment, as I now call it, family court, but with someone finally realised children were actually existed in these proceedings. Because honestly, after seeing a couple of these cases go through now, the new system, and yes, only a couple, so I'm not pretending to be the Oracle of Delphi here. I actually think parts of it are significantly better. And it pains me to say that. And I know, shocking, I know people in family proceedings saying something has improved. Steady yourselves. But the biggest difference in my experience is this. They're no longer waiting 6 to 9 business years before they actually doing some welfare assessment. Under the old system, you'd get safeguarding letter first, another hearing, directions, arguments about directions, somebody filing a statement at 4:59 p.m., somebody else claiming they've never received it, and then eventually, somewhere near the heat of the death of the universe, a Section 7 report. Meanwhile, the child's still sitting there like, hello, I'm here. I'm still emotionally developing over here. Pathfinder flips that around. Now, they do the child impact work much earlier. That's the newer terminology, by the way, just so you know. Usually called the Child Impact Report or the CIR, depending on the area. And honestly, that makes far more sense. Because instead of spending months arguing about who's lying, exaggerating, weaponizing WhatsApp, or writing statements like they're auditioning for suits, the court starts with what is actually happening for this child. Revolutionary concept. And the difference in tone is noticeable. And the older system could feel very adult focused. What's your allegation? What's your response? What would everyone like another hearing? Whereas Pathfinder is much more, what has the child experienced? What's the emotional impact? Is there fear? Is there coercive control? Is this a harmful conflict? Is contact actually safe and beneficial? Which, to be fair, are probably the questions we should have started with years ago. And because the assessment work happens earlier, the judge often walks into court already understanding the family dynamics, the safeguarding concerns, the child's wishes and feelings, and the risks involved, instead of everyone arriving equally confused. Now, don't get me wrong, this is not perfect. Implementation varies widely depending on the court and the judge and the Cafcass officer, whether Mercury is in retrograde and whether the printer in the court building has actually emotionally collapsed this morning. But structurally, I do think it's better, especially in domestic abuse cases, because one thing Pathfinder does better is recognizing patterns rather than isolated incidents. The old system sometimes treated domestic abuse like it was an incident on the 14th of May at 2 p.m., whereas Pathfinder is more interested in patterns of coercive control, fear, emotional harm, post-separation abuse, and the lived experience of the child is much more realistic understanding of how abuse actually works. And another thing, they seem more willing now to ask, do we even need a fact-finding hearing? Which is important because sometimes fact-finding hearings are absolutely necessary, but sometimes they become massively delayed, traumatizing, expensive, and ultimately changed absolutely nothing for the child. So the court now seems focused on what information do we actually need in order to make safe decisions. Again, sensible. I also think the earlier child impact work reduces some of the chaos around interim arrangements, because under the old model, interim contact could get ordered before anyone had really analysed the risks properly. Now, there's more emphasis on safety planning, emotional safety, practical arrangements, handovers, communication boundaries, and whether contact is genuinely beneficial rather than just theoretically desirable. And honestly, for all the criticism family court gets, some deserved, some less so, that's a healthier direction of travel, because children do not experience proceedings as a legal exercise. They experience uncertainty, tension, loyalty conflicts, fear, emotional pressure, and sometimes years of instability while adults litigate. And Pathfinder at least tries to reduce some of that by front-loading the important work. Now, whether it succeeds long-term, we'll see. Family justice reforms tend to arrive with great optimism, pilot scheme, a 78-page guidance document, and one exhausted practitioner whispering, we've had 3 restructures this year, Karen, 3. But conceptually, yes, having now seen a couple of Pathfinder cases firsthand. I do think that earlier child impact assessment is a major improvement, and it's much better than waiting over 6 months for a Section 7, definitely, without a doubt. And it pains me to say it, but then I've always said I'm humble enough to say when things are good and when things aren't so good. And this is definitely a step in the right direction.